Welcome to EQE Shots on your Euro patent brief journey with Barışatalay. Today we'll explore key scenarios related to European patent law and international applications in EQE Paper D1-2023, breaking them down step by step. We'll cover divisional applications, priority claims, oppositions, appeals, and revocations. Let's dive right in.
Question 1. Divisional applications and pending status. Scenario. Applicant A filed EPA describing two separate inventions. A first invention with two alternative solutions, B plus C and B plus D. A second invention, E plus F. Only the first invention was searched, and prior art was found against B plus C. Two divisional applications were filed. Div 1 describes and claims only feature D. Div 2 describes and claims B plus D plus F, with F as optional. EPA was later refused, and today Div 1 and Div 2 are pending. The key questions: A. Can valid patents be obtained for Div 1 and Div 2? B. Can applicant A still pursue E plus F?
Discussion. Let's analyze the case step by step. For Div 1, the core issue here is that B is indispensable for the function of the invention. Without B, the claim extends beyond the content of the original application. Once omitted, it cannot be reinstated. As a result, Div 1 cannot lead to a valid patent. For Div 2, a patent can be obtained, but feature F must be removed because it was not originally disclosed in combination with B plus D. Removing optional features does not add subject matter, so this approach is acceptable. With no prior art against B plus D, it can be considered novel and inventive. What about E plus F? EPA is still pending until the appeal deadline expires, meaning a new divisional application for E plus F can still be filed. Acting promptly is crucial to meet the deadline.
Question 2. Priority claim correction in PCT applications. Scenario. Applicant B filed an international application PCT-B, claiming priority from a US application, but with an error in the priority number. Despite receiving an invitation to correct it, the applicant did not respond. Key questions. A. Is the priority claim still valid? B. When is the last day to file a demand for international preliminary examination? C. Can the priority claim still be corrected?
Discussion. Is the priority claim valid? The claim is considered made because the discrepancy is only a minor inconsistency between the request and the priority document. As long as the filing was within the priority period, the claim stands. Filing the demand. The demand can be filed within 3 months from the search report or within 22 months from the priority date, whichever is later. Correcting the priority claim. Correction is still possible by submitting a rectification request as long as the mistake is obvious and supporting evidence is provided, such as a correctly indicated priority number in the description.
Question 3. Opposition and revocation of a patent. Scenario. Company D wants to oppose EPC but finds that the patent owner has requested revocation via fax. No renewal fees have been paid in Germany. Key questions. A. What is the status of the revocation? B. Should Company D file opposition?
Discussion. Revocation status. A request for revocation was made via fax, but the fee payment instruction was also sent by fax, which is not valid. As a result, the revocation process is not yet pending. Why file opposition? There's no certainty that EPC will be revoked, and the patent remains in force if renewal fees are paid late. Filing opposition offers protection against potential infringement claims and ensures the patent is challenged effectively.
Question 4. Correction of appellant name in appeal. Scenario. Company E transferred EPE to Company F before the patent was revoked. However, an appeal was mistakenly filed in the name of the previous owner, Company E. Key questions. A. What is the status of the appeal? B. How can the situation be improved?
Discussion. Current status. The appeal may be deemed inadmissible because it was filed by the wrong party. The correct owner must file the appeal. Fixing the issue. A correction request can be filed to change the appellant's name to the correct owner, supported by evidence such as email instructions from Company F. If corrected, the appeal will be valid as long as the right owner is adversely affected.
Question 5. Reviving a withdrawn PCT application. Scenario: Applicant G filed a PCT application but missed the deadline to submit the abstract. The application was declared withdrawn. Key questions. A. Why was it withdrawn and what are the consequences? B. How can the application be revived?
Discussion. Why withdrawn? The abstract is a mandatory part of the application. Missing the deadline led to withdrawal, which means the application loses effect in designated states. Reviving the application. The EPO allows re-establishment of rights. Applicant G must request the International Bureau to send documents, pay the necessary fees, and demonstrate that all due care was taken.
Question 6. Amending a patent during opposition. Scenario: EPH was granted with a claim to product P. An opponent challenges the patent, citing prior art that discloses the same product for a different purpose. Key questions. A. How should EPH be amended for maximum protection? B. What if the patent described P for medical use instead of fertilizer?
Discussion. Amendments for maximum protection. The product claim lacks novelty, but it can be replaced with a claim directed to the use of product P for fertilizer, which adds specificity and ensures novelty. Adding a method of producing P also strengthens protection. Medical use scenario. If the claim was related to a medical use, it must be reformulated as a purpose-related product claim, such as product P for use as a medicament, to avoid exclusions related to medical treatments.
Recap and reflection. Today we explored divisional applications and pending status considerations, correcting priority claims and maintaining legal rights in PCT applications, opposition strategies to protect against infringement risks, appeal corrections and how to ensure admissibility, steps to revive withdrawn applications, patent amendment strategies during opposition.
Take a moment to reflect on these concepts and ensure you understand the strategic steps needed to protect a client's patent rights effectively. Thank you for learning with me, and I'll see you in the next session.